Thank you, my lord. My lord, as indicated, I have taken instruction from the client, and we will not be pursuing the instruction. We will not be carrying out the instruction. We may continue with the.
But you want to argue?
Yes, sir.
And have you got your heads of argument?
My lord, I do have very brief heads of argument. If I may hand it up, I have given a copy to my manager.
Mr. Eubank?
Yes, my lord. I have received it. Thank you, my lord. I have.
Mr. Eubank, I just want to get clarity from you. Now that you are proceeding with a hearing, how long do you expect to be on your feet?
Only about 20 minutes, 15 to 20 minutes.
I'll hold you down.
Thank you.
I really will.
Yes.
Have you applied your mind to that?
Yes, my lord.
Yes, thank you. And sorry, before we proceed, Mr. Brown, time estimate
My lord,
for argument?
I will be longer.
I've got your heads, I haven't read them, but look.
Yes, but
They are not-
I'll be slightly longer, my lord. We have a lot more to cover. Than
When you say long, how
I'm looking
long?
at 45 minutes to an hour.
He will only be, he is the dominus litis.
Certainly
He'll
not.
only be 15 minutes.
Yes, my lord. Unfortunately, they've made very wide allegations which need specific replies, my lord. And they are numerous, so I'll have to go through those replies.
I have applied my mind to this. I'll give you 30 minutes. 30, 35.
My lord, I'll take whatever time the
Please
court
do
has.
your best.
I will do my best.
In fact, look, Mr. Brown, we all know what are the issues. We all know that. The issues are clear and so on. So please keep that in mind. I'm not saying I'm not going to allow you to go to 45 minutes if there is a need for that. But 30 to 35 minutes.
I will try
At
to
this stage.
contain myself.
Yeah, keep that in mind.
As the court pleases.
Yes, Mr.
As a court pleases, my lord, I've handed a copy of my heads to your lordship.
Yes, and thank
the-
you for the
Yeah,
heads.
this is a interim interdict or interlocutory interdict to interdict the second and third respondents from paying out the pension benefit of the first respondent pending the final determination of an action which was in fact instituted by the applicants as plaintiffs, and the case number GP 09-2019 on 5 December 2019 in this tribunal. The grounds are set out in page 2, paragraph 2. The first respondent was employed as the head of the State Attorney Johannesburg since 2013 until the 2nd of October 2018 when he was suspended. He faced 22 charges of serious misconduct in a disciplinary hearing in April 2019, and he decided to resign. The Minister of Police suffered a loss as set out in the particulars of claim of over 5 million rands with reference to settlements of claims instituted against the Minister of Police for DLIC, where he settled the matter without the written instructions and or any instructions at all from the Minister of Police, and we say that was in direct contravention of Treasury Regulation 12.2.4. Furthermore, my lord, it was pointed out that he very frequently and regularly briefed the counsel of his choice, Advocate Asim Ibrahim KG, over the years 2015 to 2019. In that period, he paid him inter alia for a 17-month period a total amount of 34 million rands for alleged work which was done for the State Attorney and various state departments. The SIU investigated these claims and fee notes and found that at least as a result of the investigation, after they were so authorized by the President, that at least 26,904 rand, 610 rand was paid to KG, either for amounts which he overcharged, double charged, and or for work which he did not in fact render to the State Attorney. Those are the grounds which the applicant set out as a prima facie case, that they are of the view that should the action which was instituted on the 5th of December 2019 come to fruition and evidence is laid, they are very confident that they will prove those damages. Obviously, it is premised on the fact that Mr. Lekabe, who was the head of State Attorney, had a duty of care towards them. He had the duty of care as an attorney, as said.
Mr. Ube, may I just stop you slightly there? Now that you have quoted the figure, estimated figure of the damages suffered by the second, is it second and third?
The second and third, because first of all, the Department of Justice paid him the amounts, and well, the different claims. Claims A to D is for settlements, which was done without authority, and which was the submission is prima facie overstated.
Yes, thank you. Now, at this stage, as we know from the papers, he disputes that. There is a denial about that, and he advances, in some way, his defense in that regard. But I just want you to respond to what would be at this stage, what would be the worth of the denial and the dispute in that regard in this application?
Yes. Well, it must be seen in context, my lord. First of all, he confirms that he was the Chief State Attorney. With claims A to D, he confirms, at least in claims A and B, that he authorized the appointment of KG, although he says he wasn't involved with the settlement, which was unauthorized. So that's a denial, but that is to be adjudicated upon by the court during the action. So prima facie, in due course. If this court is satisfied with regard to the particularity of the cause of action pleaded in a summons, it is submitted for whatever reasons they may have a defense or not a defense. That is the duty and the place to put that defense forward is the trial court. What the applicants in these proceedings are required to do is at least to set out a prima facie case which may be open to some doubt, and to set out a prima facie right. If this court is satisfied that we have set out that prima facie case based on the evidence pleaded and the evidence is contained in our founding affidavit, your lordship will remember there's already, although this court is not bound to it, on the principle of Hollington versus Youth, or there was already an opinion expressed by another court who found that there was a corrupt relationship between Mr. Lekabe and Mr. KG, and the court came to that conclusion after certain evidence via affidavits was presented before that court. But that is just by the way. Those facts are pleaded, it is submitted in the particulars of claim and in this application. So this court needs to be satisfied that there's a prima facie case, that we have a prima facie right to be successful in the action.
I think we have answered me already, Mr. with respect to Mr. Ube. But what I want to know, just to favor you what is occupying my mind at this stage, I'm saying the merits and the demerits of the action in due course, which is still pending. How are they relevant, in other words? Are they going to assist this court in this application? The merits and the demerits.
Yeah. The merits and the demerits, the only way in my view, that this court can form an informative view, if I may make use of this example. Say, for instance, we pleaded the case that the applicant was present on a scene of crime. I'm just trying by way of example. And he's on a specific date and place. In his answer, he comes with a version or a video clip which shows that he was clearly at another place at that day and time. a proper alibi, and the court can just by reading the cold facts on, or rather the objective facts in the papers, come to the conclusion, but this course of action is plainly wrong. Then, to that extent, the court will take notice that perhaps a prima facie case wasn't made out. But holistically, in a cumulative effect, if the court is satisfied prima facie, because at least the court must be satisfied prima facie that we have pleaded the case to be answered, whether there's a defense, whether it's good or bad. Now, in context again, the first respondent, Mr. Lekabe, is faced with the following conundrum. He was the head of the office. He claims under oath, and we have said it, to be in charge of that office. He briefed counsel. He authorized accounts. So he puts himself in the middle of the dispute, but he then tells this court that he may or may not have good defenses. He was either on leave, or it was a deputy who may have authorized the one payment and signed it off. Those are the factual matrix for the trial court to determine. But at least we can persuade this court, it is submitted, that there is a good case, or there's a case to be answered. And if those facts pleaded, both in the summons and in this application, is found to be acceptable and correct, and discharges the onus, there is a prospect of success, that the applicants may be successful. Once that is there, it is submitted, the court can take cognizance thereof, that we at least satisfied the grounds for the interim interdict which we applied for.
Thank you.
Thank you, my lord. So we submit further, my lord, that with reference to the facts which were already set out, it is common cause, it is submitted, my lord, and this must be undisputed, as we state in our heads on page 4, paragraph 5, that Mr. Lekabe, the first respondent, in his capacity as head of the office, clearly and undisputedly and unequivocally, as an admitted attorney, had a duty of care to act at all times with reasonable proficiency in his calling, as can be expected from him as an admitted attorney of the High Court, and they owed the State Departments, more specifically the second and the third applicants, a duty of care to exercise his professional skill and experience with adequate knowledge, diligence, as can be expected from a reasonable practicing attorney, and to perform his professional legal services in his capacity as the head of the State Attorney Johannesburg in a proper and professional manner, in compliance with the law and without negligence and or wrongfulness. My lord, it is submitted that it is plain that, and it is not disputed on the papers, that this advocate was paid an exorbitant amount of over 34 million rand in 17 months. Now, that is an objective fact which, when one looks at it, clearly smacks one in the face to say, but everybody in the legal fraternity should come to the conclusion, but what did he do? He was a junior counsel in a period of 70 months getting paid 34 million rand. That is undisputed. He was paid. His accounts was delivered. He was the monies were paid over from the fiscus, and that is public money, obviously. What did he do? He managed to earn a fee without any exclusions of holidays, public holidays, Saturdays, Sundays, of in excess of 75,000 rand a day. Now that clearly indicates, and should indicate to this tribunal or court, that there must be something wrong. It calls for interrogation, and we submit that the investigation which was done by the special investigator, Mr. Worman, clearly shows prima facie to this court that there was a collusive or a corrupt relationship as set out. My lord, we submit that currently the pension benefit is the only benefit or the only security that is of any substance for the applicants, because should they be successful, their judgment would be hollow if they can't recoup the monies from the first respondent. Although this court, it is only a preservation order, it's an interdict. So if this court is satisfied that there is a reasonable prospect of success, that the applicants, if they prove their case, may be successful, and they get a judgment in excess of nearly 40 million rand, will there be enough security and assets to meet that judgment? On the first respondent's own version, there is not. He has this pension benefit of approximately 4 million rand to be paid out. Remember, he resigned. He didn't go on retirement. If he didn't resign, that pension benefit would still have been intact today, because he still had 5 more years to go. But as a result of the disciplinary charges he faced, Section 21(3) of the Government Pension Act clearly was created, and that was also reiterated by the Supreme Court of Appeal in a decision of Highveld Steel, which we referred to in it, was incorporated to protect employers. And the court actually in fact states as follows, my lord,
Thank you. You favored me with a copy
of the Highveld Steel decision. If your lordship turns to page, it is page 3 of that judgment, paragraph 10, there the Supreme Court of Appeal clearly states that the object of that section was the protection of...
the judgment handed down
It is...
by Maya J.A.
Yeah,
as she was.
as she was, yeah. She's now the Judge President. It is 2009, Volume 2, All South African Law Reports, page 225, and paragraph 10, the court says clearly, and that was with reference to Section 37, which has the same wording of the Government Pension Act. It says the last sentence, the third line from paragraph 10. However, the object of that section is the protection of an employer against loss occasioned by employees through their acts of dishonesty, and it would be thwarted if an employee could simply circumvent it by resigning and claiming immediate payment of his benefits upon discovery of his criminal conduct. So clearly, my lord, and that's where we submit the discretion is given to this court and tribunal in terms of Section 21(3)(c) of the Government Employees Pension Law Act of 96. A copy was also attached to our head, for this court to come to the assistance and to the protection of the employer here, to order that the payout should be preserved pending the outcome of the action that was instituted. My lord, it was a different story, I would submit, if there was only allegations of an action instituted. But in this case, that action was indeed instituted. It was investigated since the SIU got a mandate from the President to investigate any wrongdoing and causing public funds that may be lost through the Office of the State Attorney. And
I hear you on that point, but may I ask you to respond to what the first respondent is saying? He says in his answer there has been undue delay in the institution of the action.
well,
What should I make of that? And therefore, as far as I understand his argument, this application should be dismissed on that score.
my submission, my lord, is there is no merit in this. The SIU got their mandate to investigate the Office of the State Attorney in May 2018. Now, your lordship will remember that the whole conundrum and the issue that raised the possible corruption and the corrupt relationship in the Office of the State Attorney was only discovered in June 2018, when the Kunene matter was settled in the amount of 34 million rand without authority from the Minister of Police. Only then did the investigation start. Then
Was that the matter before my sister, Judge
Keithley,
Yes.
yes. But it was in two parts, my lord.
Yes.
What happened there is in May, June, the application for rescission was launched. Mr. Lekabe was only suspended on the 2nd of October 2018 when certain investigations were done. And the interim interdict was issued by the High Court, first by your brother, the Honourable Judge Mdau, that the warrant should not be executed till further investigation. The Johannesburg Society of Advocates then immediately launched an application to suspend Advocate Kgosi as from the role of advocates and from practicing, which was granted. And only thereafter that the investigations commence. Now, my Lord, if one looks at the frequency of the merits of this case, the SIU was required to start investigating the briefing pattern of Advocate Kgosi from 2015. And in the summons, your Lordship will remember from about paragraph 3839, a summary was set out. In year 2015, he got 2 briefs. In the next year, he got 17 briefs, and he was paid a substantial sum. The following year, he got 23 briefs. The next year, he got 37 briefs, and those enormous amounts were paid to him for alleged legal services rendered by him. Now, that was the entire history which required investigations. All those accounts from the state attorneys, all those files, which were volumes and volumes, had to be investigated. Parallel to that, there was also the disciplinary hearing by the Department of Justice, and they were investigating their matter and formulating their claims for the disciplinary hearing against Mr. Lekabe. So, if one looks at the magnitude and the volumes of paperwork that was required from the SIU, first to investigate, then to establish whether there was indeed a prima facie case, because it was supposed to be done properly with substantiation and corroboration of their investigations. Clearly, my Lord, to have taken from effectively May 2018 until December 2019 is not a long time for a matter of this magnitude.
In fact, it's not December, is it not October?
Yeah, well, it was the 2nd of October.
December,
Yeah.
when the
Summons was issued, yeah. But Mr. Lekabe was still in control of that entire office and of all those files until he was suspended on the 2nd of October 2018, and he was requested to leave the office. So it was only from then onwards. And as your Lordship would appreciate, it is government. You have to follow protocol to get files, to get permission from the clients, because there's issues of privilege involved, to eventually get all the...
So the time spent, in other words, after the, is it 19th of May 2018?
Yes, yeah, when the Kuneni matter was discovered, yeah, the irregularities. Yes, over a year.
Or 1.5 years.
It is a year in 5 months, when, and obviously the SIU is a responsible and transparent entity. They can't simply issue a summons just for the issuing a summons. They have to satisfy that they have done the investigations, there is corroboration and substantiation. Yeah.
Thank you.
My Lord, so therefore we
Responding to my question.
yes, therefore we submit from page 13 of our heads of argument and the relevant case law. Clearly, in terms of section 21, this court has a discretion to order an interim interdict. The case law is in support of that. We rely on the Highveld Steel case, which I just quoted to your Lordship from, as well as from the SABC case versus the South African Broadcasting Corporation Pension Fund and others, which was reported in 2019, volume 4, SA 608, Kgosi Lekabe, more specifically paragraphs 89 and 97, where the court in essence found the following: to order the interdict, this court must be satisfied that the prima facie case was...
Where are you reading now?
On page 16 of my heads, my Lord. Footnote 10. Footnote 9 and 10. So it's paragraph 30
Yes.
on page 17.
Thank you.
Footnote 9 is the SABC case. We refer to more specifically paragraphs 89 and 97 of the SABC case, where that court says this court must be satisfied that the prima facie right in a case was made out to recover losses and more specific public money of the fiscus and the taxpayers' money here, that we will suffer irreparable harm should the interdictory relief not be granted, which is, in our view, ultimately harm to the public and the fiscus, because if the SIU and the applicants are successful, they will only sit with a hollow judgment. Mr. Lekabe claimed to be living in a house valued at 8 million rand, but he concedes he's heavily bonded. So there's not much, we submit equity in it. The irreparable harm is clearly that this may be the only security if the applicants are successful, that they may be able to execute against rather. My Lord, there's no further security which he may or which he can put up for the claim in excess of 40 million rand. So therefore we submit we have persuaded this court, or should have persuaded this court, that we will suffer irreparable harm, that there is no further or alternative effective remedy available to us. That goes hand in glove with the second ground, and furthermore that the balance of convenience favours the applicant in this instance. My Lord, with reference to the balance of convenience, and I'm now on page 17 of my head, we submit of my heads of arguments.
But isn't that, I mean, if you have persuaded as you have done, Mr. Yube, when it comes to the whole question of prima facie right, is there a need for the other requirements? The court to be persuaded there. Are they not, in other words, speaking for themselves? That's what I'm asking.
Indeed, they should speak for themselves, my Lord. But the court has to look at it, to say, but I am satisfied.
Yeah.
Holistically, with a cumulative approach, I'm satisfied that a case has been made out for an interim interdict, because we say, with respect, my Lord, and that cannot be disputed in our view, there's no prejudice to Mr. Lekabe. That pension fund will be reserved there. It will run interest and accumulate interest. If the SIU is unable to persuade the court that they have suffered any damages, then he will get his full benefit together with the accrued interest. In the meantime, he's gainfully employed with Skosana attorneys as an assistant attorney. His wife is gainfully employed. He was gainfully employed throughout, except for his resignation, where he just...
But in his papers he said, I'll suffer.
Well,
if I'm not able to access my pension fund.
my Lord, in our submission, that's a lip
In fact,
service.
as you know, owing to that, he has actually approached the High Court
Yes,
and sought that his pension be paid out to him.
he did approach the High Court, and the SIU did file an application to intervene before this application was launched. But, my Lord, we submit the following. That claim of alleged prejudice is only a mere lip service. There is no substantiation for it. In addition to that, we say he is in exactly the same position if he didn't retire, because he would still have been working at the office of the state attorney, earning his salary. He just jumped from one position of employment to another. He's now a private attorney, so he's gainfully employed. His wife is still in the same position. And then we have set out that for the period 2016 to 2018, an amount of cash over in excess of 1.2 million rand was paid into his bank account, and a similar amount of 1.4 in his wife's bank account. In these papers, he responds and he says, well, it was gratuitous payments from either friends or family members or his children. So if they paid him over that period those amounts of cash, in total it is 2.5 million rand. Clearly those friends and families can, if he really if he is in real financial dire straits, can also assist him pending the outcome of this action to be instituted. But he and his wife...
Mr. Yupa, just there, I think his response there would be that, please, why have you got to advise me about approaching my relatives and my children to assist me?
Well, my Lord, the point of departure is with respect. He is gainfully employed as a senior attorney.
Yes.
He is a senior attorney. His wife is gainfully employed. In his capacity of being gainfully employed, both of them, they did manage to pay their monthly expenses. The position should remain the same. So those are our submissions with respect. My Lords, with regard to costs, we submit that obviously, as your Lordship can see from the opposition to this application by Mr. Lekabe, we submit we've made out a substantial and overwhelming case in our application which we launched. Mr. Lekabe opposed it on a grounds which he clearly is entitled to. Be that as it may, when it comes to costs
But
is
if
always...
you're entitled to oppose, then why do you seek the higher scale?
Yeah, that...
Attaining-
I concede, my lord, the only reason why the higher scale was claimed is for the grounds and the corrupt relationship which was pleaded and which we submitted and this court this whole application. Because
But that will only be determined in
that
court.
is to be determined in the action. So in all fairness and correctness, my lord, if cost is granted, it should be only party and party cost,
Yes.
including the cost of two counsel.
Anything-
Cost is always in the discretion of the court, and obviously it usually follows the result
Yes.
unless the court decides otherwise. So that would conclude my address. And I apologize, I see I was about 5 minutes over. Thank you.
Well, of course, there was also the intervention of the court.
Yes. I've prepared the draft order should the court, but let's listen to the argument of the respondents first.
Yes, Mr. Brown.
Thank you, my lord.
Mr. Brown, I'll still hold you on the time that I indicated to you. And but your submissions, I think that in a way they are largely facilitated by the fact that you had the argument of the applicants, and therefore, in a way, your submission should be restricted.
Lord,
But I won't stop you within your time.
Lord, I will try my damnedest to assist the court in that regard. My Lord, I want to start firstly by what my learned friend has submitted.
Do we agree that it's now 20 to 3?
My Lord, that is fine. My Lord will certainly advise me when I've gone over the time allocated to me. My learned friend has submitted what the legal grounds would be for the relief that they seek. What my learned friend does not alert the court to is what the courts themselves have said in regard to those grounds. And in that regard, my Lord, I refer to one matter in my heads of argument. That is the University of Limpopo versus the Government Employees Pension Fund matter. I have a copy of the judgment. I did not attach it to my heads of argument.
You can end it down.
As the court is.
Have you got a copy?
I have a copy, my Lord. I haven't made a copy for my learned friend, but I have for the court.
Yes, thank you.
I want to refer the court to paragraphs 15 and 16 of the judgment, my Lord, which deals precisely with the issues that my learned friend has raised. Firstly, with regard to what is required to obtain an interim interdict, says the prima facie right or well-grounded apprehension of irreparable harm if the interim relief is not granted. The balance of convenience favors it, and 4, it has no other satisfactory remedy. Paragraph 16 is more relevant, my Lord. It says specifically, the onus is upon the applicant to put forward sufficient evidence to establish a prima facie right, albeit open to some doubt. It will never be enough for the court to merely accept the applicant's allegations. The applicant must set out the facts in as complete a way as the circumstances demand. The stating of bold, unsubstantiated allegations poses the risk to the applicant that significant doubt will be cast on his version. The proper approach is for the court to consider the facts set out by the applicant together with any facts set out by the respondent, which the applicant cannot or does not dispute, and to decide whether, with regard to the inherent probabilities and the ultimate orders, the applicant should on those facts obtain final relief at the trial. The facts set up in contradiction by the respondent should then be considered, and if they throw serious doubt on its case, the applicant cannot succeed.
But Mr. Brown, that has been the position when it comes to this remedy since 1949. I see that you quote it at length in that paragraph 16.
Yes.
Since 1949. As you know, Webster against Mitchell,
My Lord,
which was the then WLD decision.
precisely, my Lord. All we are asking is that the court applies what the law is in this case. And to do that, the court must look at the allegations and what Mr. Lekabe says about those allegations, my lord. If we can start with the main allegation that Mr. Lekabe was involved in the Kunene matter and that the state lost 34 million in that matter, my lord. That is palpably untrue. The judgment was rescinded, so there was no money lost. So that is completely misleading to say that in the Kunene matter, Mr. Lekabe caused the state to lose 34 million. The state did not lose 34 million. The judgment was...
Is that judgment not going for appeal?
Yes, precisely. It is going for appeal, my lord.
So what's the basis now for saying that?
Well, my lord, the respondents themselves question whether the appeal would be successful. I mean,
sometimes people are out to say that.
my lord, the fact of the matter,
They don't want to agree.
my lord, I agree.
You don't have merits.
My lord, I agree,
It's
my
in a
lord.
manner of speaking sometimes, Mr. Brown.
My lord, we are talking
We can't
about,
hold them down on that.
we are talking about a factual situation, my lord. There is a court order which rescinded that award. The money that they say was lost was never paid out. So it cannot have been lost if it was never paid out. So that is deliberately misleading this court to say that they lost that money. That is the point I'm making.
Well, I understand. I
Yes.
mean, I understand what they are saying. I also understand what they are saying. So, can we move from there?
Certainly, my lord. The second issue, my lord, that they raise, they say Mr. Lekabe briefed Mr. Kaji on numerous occasions, and they give figures 12 times and 17 times and 59 times in a year. They do not provide the proof of those briefs. What they do provide, they say in their own papers, Mr. Lekabe kept a register of the briefs that he gave to the various council. And they provide a copy, and we provide a copy of those that register. From that register, my lord, we show that Mr. Lekabe briefed Mr. Kaji on 4 occasions, and we give the court the dates of those briefs, based on the same records which they rely on, my lord. So that allegation that Mr. Lekabe briefed Mr. Kaji more than 100 times is simply not true, based on the records which they themselves
But,
provide.
Mr. Brown, isn't it that a matter which will be traversed in court in due course
No, my lord.
and a determination to be made?
No, my lord. We're saying that this is a matter where they have made...
But because, you know, I'll tell you why I'm asking that question, in all fairness. You see, because to me, it presupposes the submission you are making, that what the applicants have got to do, they have got to prove not the prima facie right, on balance of probabilities. This is what you are saying. And they are not seeking a final order. They are seeking only an order which is not final. Interim order.
Well, Lord, our submission is simply that the law says in order for them to get that order, they have to cross certain hurdles.
No.
One of the hurdles is this aspect that I'm dealing with.
But you have just read to me now that it does not need to be.
No, my
The
lord.
test is not a question of balance of probability.
No, my lord, that is not what I've referred the court to. What I've referred the court to is the standard of proof in these proceedings that the applicants must meet in order to satisfy the court that the remedy they seek can be given. And in the terms of what the dicta there, it says very clearly, if the case that the respondent puts up throws serious doubt on the case of the applicant cannot succeed. That is what the law says, my lord. And we are saying the case that we are putting up shows that the applicant cannot succeed, my lord. Their case is weak because their own documentation contradicts the allegations that they make. They say Mr. Lekabe briefed Mr. Kaji more than 100 times. Their documents show he was briefed 4 times by Mr. Lekabe.
Yeah. Mr. Brown, let me put it this way. On this score, perhaps that will be my last question. Do we agree that we are not necessarily embarking or traversing issues that properly should be issues shared for the actions?
We agree, my lord. However, the law requires in these proceedings, for the kind of relief that they are seeking, that they satisfy the court in respect.
And that in due course, sorry to interrupt you, and in due course, then the ever-standing rule about balance of probabilities will apply.
My lord,
But not in this process.
we are submitting that the law.
In this application.
We are saying in these proceedings, according to the law, and the case law that I've referred your lordship to is on all fours on that aspect, on the onus that they have to meet. And these are the...
But it includes the test of balance of probabilities.
My lord, may I ask, is your lordship refusing to hear the aspects that I want to raise to show that their case is weak?
No, how can I do that?
My lord, your lordship keeps on referring me to the balance of probabilities. I am saying the law, as I have quoted cited from this case law, which is on all fours with this case, says they have an onus. It says that if the respondent...
No, but what is wrong then, Mr. Brown, if I pose a question to you, asking you, because this is what is occupying my mind, that in terms of the submission that you are making, not in respect of the cases, which I agree with. I actually quoted to you a case that you did not quote yourself. I said that is a standing law emanating from Webster case versus Mitchell, 1949. I agree with it. But in terms of your submission, you want this court now or tribunal to exercise its discretion relating to balance of probabilities.
My lord, I disagree. I am saying that the law requires this court to apply the law as it stands. And
Yeah, but now that's fine. That's fine. You can do that.
I'm asking the court then to hear me out and
Yeah, proceed.
And I'm saying again, my lord, one must look at the allegations that they make, because the law says bold allegations are insufficient. And if those allegations are countered by the respondent with evidence that disproves these allegations, they cannot succeed in obtaining the relief that they seek. So what I'm saying is the court must look at the allegations, the court must look at the respondent's reply to those allegations, and must then decide on the basis of what the respondent says if they have satisfied the onus which the law sets for them. That is all I'm saying. And I was busy going through the various aspects which my learned friend has raised with regard to the allegations. And I'm showing that we have put up evidence.
I think you have made your point.
Yes.
That you can move on.
Yes, certainly.
To another point.
You know, my lord, I can take the court through all of the allegations with regard to the overpayments that were made, allegedly made to Mr. Kaji by Mr. Lekabe. If your lordship has regard to our papers, we have indicated that on 9 occasions when Mr. Lekabe was given the accounts for Mr. Kaji to scrutinize, he reduced those amounts, my lord. He reduced the charges that Mr. Kaji charged. So he acted diligently in those instances. The remainder of the fee notes for Mr. Kaji were not scrutinized and authorized by Mr. Lekabe. They were authorized by someone else. They were authorized by his deputy. They were scrutinized by an officer of the court. an attorney in the office of the state attorney. In their papers, my lord, they say that this attorney acted on the instruction of Mr. Lekabe, and therefore Mr. Lekabe should be held liable for those incorrect fee notes and the payments of those fee notes. But what they are in fact saying is that Mr. Lekabe asked an officer of the court to commit a crime, and that officer of the court agreed to commit that crime and pass those fee notes, my lord. That cannot be sustainable in the case for the applicants in this matter, my lord. It cannot guarantee them or reassure them that they have a reasonable prospect of success with the summons that they have issued against Mr. Lekabe, my lord. So I'm simply saying, my lord, every allegation that they have made with regard to the alleged criminal conduct, negligent misconduct, or lack of diligence on the part of Mr. Lekabe has answered to that. And
but Mr. Brown, they are not claiming that they have proved their claims. It's not, as I understand it, they are not saying we have proved these claims that we are making, simply because that would be an exercise to be embarked upon in court in due course.
I agree, my lord. But what I've cited to your lordship says that if they make allegations, not if they prove their case in this court, if they make allegations in this court, they must make those allegations in such a way that there is some substance to it. It must not be just mere bold allegations. And if the respondent can cast sufficient doubt on those allegations, not disprove it, but if he casts doubt on the allegations, then they cannot succeed in obtaining the remedy which they seek. That is my argument, my lord. And I'm demonstrating to the court that in respect of every allegation that they have made, Mr. Lekabe has cast sufficient substantive doubt by way of documentary evidence that the allegations that they are making do not have any substance, and that the prospects of them succeeding, even in a trial, are weak. But that is not a consideration for this court. The trial, the outcome of the trial matter is not a consideration for the court. What the court must look at is the allegations, the evidence that Mr. Lekabe has put up, and if Mr. Lekabe has put up sufficient evidence to cast doubt on those allegations, then the court must rule in his favor. That is all I'm saying, my lord. And that is the law. So that is my argument. If your lordship will allow me to go through every allegation that is...
You are not, provided you summarize.
Yes,
because you must look at your wristwatch, like I'm doing.
No, certainly.
There is time.
Certainly, my lord. So I want to deal with those allegations then, my lord. I've dealt with the issue of the Kulele matter. There has been no loss. The judgment was rescinded.
No, you have already made that submission.
I may have dealt with the allegation that Mr. Lekabe briefed Mr. Kaji in more than 100 matters. The evidence that we have before the court is that he briefed him in 4 matters. The allegation is that Mr. Lekabe overpaid Mr. Kaji. We've illustrated by way of the evidence before your lordship in the fee notes that Mr. Lekabe did not appoint Mr. Kaji in those matters and also did not approve those fee notes. In the matters where he did scrutinize Mr. Kaji's fee notes, he reduced the amounts substantively, my lord. So that disproves the allegation that he favored Mr. Kaji.
I had you when you said that.
Yes, my lord. With regard to the allegation that he authorized settlement of the matters, they refer specifically to a matter Molele in the papers, my lord. We have provided in our papers proof that that matter was not settled, that that matter was actually disposed of by way of a stated case, my lord. So once again, that allegation falls by the wayside. They make the allegation that in his capacity as the head of office, Mr. Lekabe approved and authorized every appointment of counsel that was made. We have provided the register showing which of those matters. They say further in Mr. Lekabe says that whenever he approves a counsel and authorizes appointment of counsel, the attorney who is dealing with the matter will approach him and give him a background to the matter, and then thereafter he will approve those matters. We have shown from the register, as compared to the fee notes.
These incidents that you are referring to, Mr. Brown, are they appearing in your heads of argument?
No, they are not in the heads of argument, but they are in the papers, my lord. I've merely set out the law, and I'm asking the court to apply the law to what is contained in the answering affidavit and the evidence, the documentary evidence that we are putting before your lordship. So I'm dealing with each of those allegations that the applicants rely on, and I'm showing to this court, I'm trying to show to this court that each one of those allegations, my lord, are not true, that there is evidence to show that their own evidence contradicts what they are alleging, my lord. And if that is the case, my lord, then the court must take that into account in not granting them the relief that they are seeking, my lord. I know that in the time that I have available, my lord, it's not going to be possible for me to go through each and every incident.
But I haven't stopped you yet.
It's certainly, my lord. I'm just worried that if I do embark on that exercise, your lordship will remind me that I only have 35 minutes, and then I cannot deal with the other issues that I have raised. So if your lordship is willing to allow me to go through those allegations, I will do.
If there is no repetition?
No, it's no repetition, my lord. What the applicant has alleged is that there was a corrupt relationship between Mr. Lekabe and Mr. Kaji. And for that it relies on the allegations, once again, that Mr. Lekabe briefed Mr. Kaji on more than the 4 occasions that we refer to, and also paid him in excess of the fees that he was entitled to. As I've indicated, my lord, if that is the basis of the corrupt relationship which they allege, then the evidence, the documentary evidence, disproves that there existed such a relationship, because he was only briefed 4 times, and as I've indicated, my lord, the fee notes were approved by the deputy, Mr. Dulam, and it was scrutinized by the respective attorneys who dealt with those matters, my lord. So that allegation then is questioned seriously by the evidence that is before your lordship. My learned friend asked the court to draw an inference on the basis that Mr. Kaji withdrew large sums of money in an unspecified period of time. They say over a number of years. And in this unspecified period of time, large sums of money to the tune of R1 million were deposited into Mr. Lekabe's account. Firstly, my lord, the allegation is very vague and unspecific. You cannot say that over a large period of time, this money. We need to know specifically, and this court needs to know specifically on which dates how much money was withdrawn, and on which dates and how much money was deposited into Mr. Lekabe's account, in order to draw an inference that the money that was drawn by Mr. Kaji and deposited into Mr. Lekabe's account or his wife's account have any relationship or are related to each other. So they have said that the inference is inescapable. There is no other inference that can be drawn. Mr. Lekabe has said, in the period of when I've had this account, I've received numerous amounts of money. I've made a loan of 160,000 rand from Woolworths, which went into my account and reflected as cash. My daughter has given me monthly money for her living with me. I'm paying an installment for my daughter on a motor vehicle. She repays me that money every month. I inherited cows from my father. My brother sold those cows for cash and deposited the money into my account. So he's given, to the best of his ability, an explanation for cash that has been deposited into his account. Unless and until the applicant shows what money and what period they are referring to, it is unreasonable to expect Mr. Lekabe to give a detailed account of every cash transaction that occurs in his account. He even says in his papers, my lord, we arranged an overseas holiday for our family. Everyone's contributions for that overseas holiday was paid into my account, and that is also reflected as cash in my account, or inter-account transfers, my lord. So on that score as well, the case that or the allegation that the applicant is making is vague and is unsubstantiated before you today, my lord, because it is only an allegation with no substance, no detail. Essentially, my lord, those are the 5 areas which the applicant claims are the areas in which Mr. Lekabe has either acted criminally, negligently, or has breached the Public Finance Management Act, my lord. We submit that if one has regard to what I have put before your lordship and the documentation which I have referred your lordship to, and the explanation which has been given to the court by Mr. Lekabe in respect of those aspects, it does cast serious doubt on the case or the allegations which the applicant has made. The case law I have referred your lordship to says very specifically that if the applicant does not provide sufficient cogent information to this court about the allegations that it makes, it runs the risk of doubt being cast on its allegations, as we have shown in this matter. And the case law says very specifically, if this court finds that such doubt has been cast on their case, then they cannot succeed in the application that they have made. And that is what we are asking. If I may then address your lordship on the further aspects which my learned friend has raised with regard to the other requirements for an interim interdict. And I want to start first, my lord, with the allegation or the well-grounded apprehension of irreparable harm if the interim relief is not granted. What they say is the grounds for their well-grounded apprehension of irreparable harm is the fact that the first respondent has applied for his pension fund. They say that that triggers their apprehension of irreparable harm. My submission is, my lord, it is his right on resignation to apply for his pension fund to be released to him. If they claim, as they say, that they have an apprehension of the irreparable harm, I've indicated to your lordship that in the papers that when he made this application to the High Court to compel the pension fund to release those funds, they have an opportunity, because it is provided for in the Government Employees Pension Fund Act as well as the regulations, for them to intervene in that application. My learned friend has said to the court now in his address, they have in fact intervened before they embarked on this application, my lord. If they have then embarked on that intervention exercise in that application, my lord, why are they before this court again on a semi-urgent basis? They should then ventilate the issues that they are now raising to try to interdict the pension fund in this court. They should ventilate those issues in the court where the application is, in terms of Section 21.
Well, I can't make a determination, Mr. or I'm unable to make a determination in that regard, Mr. Brown, because that application is not before me.
Well, certainly, my lord, but they mention it, my lord, and we mention it.
Yeah.
And they say we have intervened.
Yes.
And we are saying, my lord, in terms of Section 21, they are entitled to intervene. And they are entitled to have recourse to the provisions of Section 21.
But am I not entitled then to make the observation that I've just made?
Well,
to you, in spite, notwithstanding the fact that they raised it, you raised it, and you take it up just now in your submission. Can't I make an observation that, unfortunately, I'm not seized of that application of Mr. Lekabe. It's before the court, in the High Court. In other words, what I'm trying to say is that now, why should I make a determination in that regard, one way or another?
I will tell the court why.
That the application is not before.
I will tell the court why, my lord. Because in the case law that I have cited, one of the further requirements for the interdict to be granted, which they seek, is that they must have no other satisfactory alternative remedy. I'm saying, my lord, that the alternative remedy is that intervention in that court.
But to my mind, what they are doing, and I'm not in any way defending, But what they are doing, they are saying we have instituted an action since the 5th of December last year. Now, because we are aware of the application before the High Court, we may as well then succeed where we have instituted the action.
My Lord, all I'm saying, my
and exploit this application
Lord,
and try to satisfy the court in this application.
I'm saying, my Lord, that they are now forum shopping because they say, my learned friend said, we did intervene in the application which is before the High Court, the application for the pension funds to be released. He says, we have intervened, and only after we have issued summons in this
I'll
matter.
listen to Mr. Yube no sooner you sit down, whether they are shopping or not. But please proceed with another submission.
My Lord.
I had you on that one
Yes.
of intervention.
Yes, my Lord. That goes to the issue of alternative remedy, my Lord, which is a requirement. With regard to the alternative remedies, once again, my Lord, the allegations are broadly that the money that is in question, or the money that has been wrongfully paid out, has been paid to Mr. Kaji. That is the allegation. The high watermark of their allegation with regard to any benefit to Mr. Lekabe is the influence that they are asking the court to draw from the cash deposits that were made into his account. And let's say it's 1.1 million into his account and 1.4 million into his wife's account. That implies that the bulk of the money which they are seeking to recover is in the hands of Mr. Kaji. Surprisingly, they do not pursue Mr. Kaji to recover that money. My submission is, my Lord, in terms of alternative remedies, they have a glaring alternative remedy. They should pursue Mr. Kaji and get the money from Mr. Kaji. So they cannot come to this court and say, we have no other alternative remedy. The person who is alleged on their own version to have received the money is Mr. Kaji. Go to him and get the money from him. My Lord, my submission is simply this. They fail in the allegations that they make. They fail in the respect of the alternative remedy. They fail with regard to the well-grounded apprehension, because you cannot say that we are apprehensive because he's applied for his money. In his papers, he says exactly what he intends to do with the money. He says, I will apply it to the bond that I have over my property, because I'm afraid I will lose my property. I cannot service the bond. I need the money to service the bond. That application of the money to the bond is not throwing the money away. It's not spending the money. It's investing in the equity in the property. It's money that will not be lost to the applicants should they need any asset to look to recover their money. They can attach the property. And the equity that money from the pension fund would have provided will still be in the property. It's not going to be lost, my Lord. They are saying we have approximately 4 million in cash, which is going to be paid to Mr. Lekabe. Mr. Lekabe says, I'm going to take the bulk of that money and put it into my bond. That cash is not lost, my Lord. It's not going to spend it on frivolous items. He's investing in the property and building the equity, which they will have access to. So that argument again, my Lord, I submit, does not hold water, that the money is being frittered away, my Lord. By the way, my Lord, the application that is before your Lordship is an interdict. It is not an anti-dissipation order that they are seeking, my Lord. So all they are saying is to the pension fund, hold on to the money until we are done. When we are done, you either pay it back to us or you pay to Mr. Lekabe. If the problem is anti-dissipation, all they need to do is that allow him to put that money into the bond, and they can get an anti-dissipation order against that property of Mr. Lekabe. They can say, you may not sell this property until we have finalized the action that has been taken against. That would be the same kind of security. But the order that they are seeking now places Mr. Lekabe in hardship level, because he as much as they say he's earning a substantive salary, they do not indicate why they say that, my lord. He's a professional assistant in the company. They work on a fee basis. If he raises sufficient fees, he gets paid sufficiently, my lord. They have not indicated that he's raising, writing up large fees for him to be able to say he's living substantively. His application to the High Court in respect of the release of the pension money is before the court. The contents thereof clearly reveal that as we speak, his accounts are in overdraft already, my lord. He says, I've received notification from the banks already with regard to the non-payment of my bond and the overdraft that I am now operating on. I'm not making sufficient money to sustain the lifestyle that we have been living. To say to him now, go to your family and go to somebody else to get money, my lord, is totally unreasonable. Why should he do that when he has a resource that he can draw on of his own? My lord, my submission is that the applicant has not made out a case for the interim interdict. They do have an alternative remedy, my lord, and they can go to the court in which they have already intervened and make out a case for that money which they are claiming to be held in trust, not paid out by the pension fund until the matter is resolved. They do not have to come to this court, my lord, because that is forum shopping. That is my submission, my lord. I trust that I've used up my 35 minutes.
I so trust.
As the court pleases.
Thank you. I will get now that you have made your last submission.
My lord, I'm satisfied. Just with regard to the
You
issue.
will have another bite in the cherry.
Certainly, my lord.
So I just want to be sure about you.
I just want to make a submission with regard to costs, my lord. My lord, the opposition to this
I'm
application
happy that reminded you about the court.
is the opposition to this application, my lord, is not frivolous, my lord. There are very serious allegations that are made which needed to be addressed in this court. The consequences of an order, should the court grant an order in the form that the applicant seeks, has far-reaching consequences for Mr. Lekabe, my lord. So our submission is, my lord, that even though they may succeed in the application, my lord, each party should bear their own cost, because there has, as I've indicated, there is an alternative for the applicant to use to achieve the same remedy that they are seeking in this court, my lord. Because now Mr. Lekabe has to deal with this application before this court, and also their intervention in the application before the High Court on the same issue, my lord. So that, if I submit, my lord, is unfair. They cannot attack him in two forums and expect him to pay the cost in both of these forums. His opposition in this court is justified, my lord, and it is not frivolous, as I've indicated. As the court
My lord, at the outset in reply, it is very disappointing for me that Mr. Brown would accuse Mr. Fisher and I of deliberately misleading the court. He says that we misled the court to say that the state suffered a loss of 34 million rand in the Kunene matter. If he read the papers, which he was supposed to do, and read it properly, you would see on page 20, paragraph 1, we say the cause of this entire matter arose when the minister, when the Kunene matter was settled for 34 million rand, and we say the Minister of Police then brought a rescission application to set the judgment so obtained aside, which rescission was granted on the 18th of October 2019, and lodged a complaint to the, against KG for the serious misconduct with the Johannesburg Bar Council. Again, on paragraph 26.13 on page 26, we say that the conduct of the first respondent in KG with regard to inter alia the Kunene matter almost resulted in a financial loss to the SAPS in the amount of 34 million rand without taking all costs involved if the order was not rescinded on 18 October 2019. So for Mr. Brown to stand up in this forum and to say that I deliberately mislead the court is not becoming of an advocate, because that's not what we've done, and the papers clearly state so. But that matter, I'm leaving it there. My lord, with regard to the particulars of claim, we, or rather the SIU, issued summons against Mr. Lekabe based on DLIC, that in 4 matters he settled matters without authority, causing the Minister of Police to suffer 5 million rand. In respect of claim E, that he overpaid or caused Mr. KG to be overpaid the amount of 26 million rand. That cause of action is based on DLIC, and we inter alia rely on paragraph, or rather on section 45 of the Public Finance Management Act. So those are the grounds for this interdict. My Lord, and the only other issue in reply I wish to address the court, he says, they make mention that all of a sudden Mr. Lekabe states in paragraph 89, rather paragraph 98, page 187 of the index pages, that he in fact cut down Mr. KG's accounts, and he then annexes 6 examples thereof. Those examples, your Lordship, will be found on page 1035 up to 1058. But if one looks at it, my Lord, he only started to cut those down, if you look at the dates which Mr. Lekabe started doing it, is in July 2018. That is after the Kuneni matter was raised and came to the 4th, to show that Mr. KG was paid amounts which were not due to him. So only after the Kuneni matter, the application was launched in May and June 2018 for the rescission, did Mr. Lekabe all of a sudden decide to check his accounts and then start reducing it. So it must be seen in that context, my Lord. My Lord, and then the only other issue of the so-called, we were unaware that Mr. Lekabe brought an application to force the government pension fund to pay his pension in October 2018. We only became aware of that on the first day of November 2019. On that day, simply a notice of intention to intervene in a post was filed, and it was stated that in due course an application will be filed. That application, and I can hand it up to this court as proof thereof, that application was never filed.
Well, I haven't had sight of the application, but I hear the submission by the representative. I don't think it makes any difference what the content of the application is.
So after that, the events of this matter took over, because we were in the process of putting the summons together and setting out the case, and then I think the publication of the tribunal only came about in late November, if I'm not mistaken, after the 16th or the 18th of November 2019, and then we got instructions to approach this tribunal for the issuing of the summons as well as the interdict. And
that was the commencement of the operation.
That was the commencement, and that's the reason why. So we are not currently we're not before the High Court. We've simply filed that notice because should it have proceeded, my Lord. Then finally, So the cause of action is not a Kunene matter. It's totally misplaced, and it's very disappointing for Mr. Brown to say that we deliberately misled the court. We didn't do that, and it wasn't done. My Lord, just on the issue of the government pension fund, we, since the lunch hour, we received now, in fact, a notice to abide by the government pension fund. So your Lordship asked for the summons, but we got something better. They have actually apologized and say they have now they have received it and they will abide.
What I raised with you,
yes, that's the appropriate thing to do. Yeah, my Lord. And then lastly, to the extent that it may be necessary to assist the court, we've prepared draft orders, if I may, if whether the court want it or not, my Lord. Thank you, my Lord. I have no further submissions.
That is for to assist you.
Yes.
It remains for the court at this stage to thank counsel for their submissions, which I'm sure assist the court in making a determination. I see that we are very close to 25%. At this point, we shall take an adjournment, and just before 4, the court will resume the proceedings. I do hope and trust that by that time, the court will be in a position to render down the judgment.
All rise.
I'm not going to down my client. I have an obligation to represent my client. I do it fearlessly.
As long as you can deal with that thing. As long as you can deal with that thing.
Thank you.
Of the gate.
Are you looking at the exact? I don't want to give you the spelling of the name.
Yeah, chair.
Oh, what? The handwriting. Okay, okay, everyone is it? The security. Next. Thank you. It was many from school. Okay, it's G I D F O N I E.
Yes, okay. Thanks so much. The name is Yolanda Kumani.
I would.
Ayanda.
We'll have to take it up from our camera like inside.
Yes.
It's not connected. To remove our camera like not get it.
I don't see that now, but basically.
Just so it will move us to next week.
We're talking about some members of team. To have both the courts for 66522 and the amount is 66522
So when it might be yeah,
per day
something.
for 519.
Well, wouldn't I leave them?
That was what he was saying, that with no weekends, we probably come back on the 6 days. Yeah. It's like the matter was settled and, yeah. Despite that the matter was
Yeah. Well, would I get
Le faccio l'esperto di stessa naturale e usiamo una computer.
Yeah.
Because this actually kind of explains a little bit about the whole settlement and the backdoor dealings and stuff like that.
Okay, there's a story like elaborate. This is very elaborate.
Yeah. It's from when did Lekabe resign? 2018 or 2019? Okay. A lot of these speeches and so on. He said 2018 and then he said 2019.
Yeah.
I got confused there, but this article kind of says they only were found out in 2019. Yeah. Yeah, I found this slide on this earlier on. Sorry, because I went but you
I mean, the thing is, it's only an inch around the border as well.
yeah, it's not something you did.
And he's still waiting.
No, but they still got
Yeah.
no, it's not that.
But he's mad.
Even the judge communicates did say that it's a relation between yeah. Yeah, we did.
When did you retire? Suspended October 2018.
I was not making sure. October has yes. Working and continuing assistance and the work expire.
So you said, he's lost over 5 million rand in claims against the damage, you said. What you there was saying, you've got 34 million, one which you stopped. Then you say over the above, 65.
Already on Friday, like we all do that. Why would we hold it unless it's
Okay, I'm speaking on the level. 1, 2, 2, 2, 2, 2, 2. 1, 2, 1, 2, 2, 2, 2, 2, 2. Okay, I can not sure I post it aside as I can. I don't know. Okay.
We will see. We
2009.
Share, okay. I just posted them up now. Check them now. Okay. 1, 2, 2, 2, 2, 2, 2, 2. 1, 2, 2. I'm still picking up. Go 18, go 18.
One, two, 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 and then this one, still the same. 1, 2, 2, 2, 2, 2. Okay.
there was 5 million, right? And then the 26 million.
Just check now. 1, 2, 2, 2, 2, 2, 2. How are they now? Is there any difference? Still, okay, 36. We'll try to boost them from the inside. Because they flew here on the channel, on the camera channel.
That's why the test the same process designed the report to the answers. Until such time is now, and see the answer from the
Just say that, then you tell me. Just say, yeah. Yeah. Pending that text, when is that?
No problem.
Oorweg van waarskynlikhede.
Of maar wil jy nie weet wat balance? Wil jy
Sy
nie weet
gebruik geen plaas.
wil jy nie weet wat die balance of convenience?
Ag, convenience, kies toch.
Oor wat die
Balans van gerief.
balans van gerief, dis reg.
Wat moet hulle dan doen?
Met ander woorde, jy weet, jy moet kyk in wie se guns die gerief is. Hy word nie benadeel nie, want sy geld bly dinges. Ons sien net hy kan dit nie gebruik rente trek. So die balans van gerief en ons het ons interdik in plek. So as ons suksesvol is, kan ons op sy geld beslag lê. So daar's geen nadeel nie. Wie se nadeel is die grootste?
Dis die balans wat jy doen. Die se nadeel is die zwaarste ding. So ons nadeel is sal leer judgment is sy nadeel is. Ons sien net want dit sou sy geld later kry.
Ja, hy sê hy wil nou sy geld hê want hy wil dit spend. 4 miljoen.
Skat ons min of meer 4 miljoen. Ja, dis al wat daar is. Ja.
So druppel in die emmer. Hy is nie ons kollega nie.
Ook hy is niks van ons nie.
Op hierdie stadium is hy niks van ons nie.
You know, I know you gave one journalist the names of the. I didn't write them down, but now someone just sent me a WhatsApp and I don't happen to see the guy. How's it?
The names of what do you want?
Cancel. because you know,
Okay, for SIU,
yes, maybe.
nee, police and justice is
I'm sorry to do this again. David Jubert, okay.
senior counsel and GVR Shay.
Okay.
And for
the respondent.
Lekabe.
Yeah, for Lekabe.
Desmond Brown.
Are you fine with this?
Yeah, that's fine.
Because the media say they tell me they don't go for abbreviation, they want to full name, so don't worry. Then I will be able to.
And now you have a full name.
Yeah, no, this is
Okay,
sufficient.
this
is sufficient.
His real name is Van R.H. Van Rijn. He's got the surname for a name.
Oh, really?
Van Rijn for sure, yeah.
Oh, lucky him.
And it's been following my whole life.
Oh, no, lucky you. No, thanks. Let me just text you. Thanks.
Okay. Nee, ons het net een gekry.
Ek dink dit op jou e-mail.
Van ons finale hoofde. Ja. Van ons. Maar ek het dit gister vir jou ge-email.
So jy het niks van nie.
Nee, dit is niks van nie.
Dis nie wat jy sê nie.
Ek het hoofde vir jou ge-email.
Ja, consider wat jy gestuur het.
Ja,
Dis nie wanneer jy dalk iets verander aan die
Ja, dis
sê jy die laaste goed weer.
Nee, dit is op die enigste goed wat ons verander het aan is VJ se verklaring.
En ek weet jy kan weg. Ja, maar dis
Kering, draaf.
Dan hebben we dat echt niet vast.
I'm actually waiting for my registrar to come in so that I can proceed with the judgment. But I think before we adjourn, enough was said about the handing down of the judgment. So I'll proceed. Paragraph. This is an application where the applicant, the SIU, seeks an order that restrains or interdicts the second and third respondents, namely Government Employees Pension Fund and Government Pensions Administration Agency, respectively, from paying out pension benefit held by them to the first respondent, namely Mr. Lekabe, pending an action instituted by the applicant against the first respondent. I just pause here and try to ascertain, because I did not do that, if the machine is on.
Yes, it is, sir.
I proceed. In addition, the applicant seeks order of costs against the first respondent, SY, head of the office of the state attorney in Johannesburg. Paragraph. The action the applicant on behalf of the second plaintiff, that is the Minister of Police, and third plaintiff, that is Minister of Justice and Correctional Services, prays for judgment against the first respondent for damages allegedly owed to the second and third plaintiffs. The damages approximate an amount of 34 million up to approximately 40 million rands. Paragraph. The alleged damages suffered by the second and third plaintiffs allegedly are as a direct result of the first respondent's wrongful and unlawful breach of his statutory duty or duties, leading to collusive and corruptive acts with a disclosed individual, namely Mr. Kaji. The first respondent disputes all claims made by the respondents, made by the applicants in this application, and the action pending before this tribunal. Paragraph. However, the action instituted by the plaintiffs on the 5th of December 2019 is not disputed. Paragraph. In this application, the first applicant states that it has good reason to believe that should the payment of the pension benefit to be made to the first respondent is made, it will suffer unmitigated losses, as they shall have no security for judgment sought against the first respondent in the pending action, should the judgment go against the first respondent. See in this regard the matters of Highfair, Steel, and Vanna Dume Corporation Limited against Oosthuizen, 2009, Volume 2, All South African Law Reports, page 2 to 5, and it's a Supreme Court of Appeal decision. And see also South African Broadcasting Corporation against South African Corporation Pension Fund and others, 2019, Volume 4, SA, Law Reports, page 608. It's a 608, it's a South Gauteng decision. This belief has not been seriously disputed by the first respondent. In addition, the pension fund, according to the applicants, will stand as security for the cost orders already granted against the first respondent by the High Court in Johannesburg in a judgment delivered there. Paragraph. The first respondent in this application has put forth a number of grounds disputing claims made by the applicants, including denial that the applicants have established a prima facie right for the remedy it seeks. Paragraph. He also contends that the applicants have unreasonably delayed bringing before the tribunal the action involving impropriety and negligence on his side, seeing that they have known since 19 May 2018 about his resignation from the office of the state attorney. He also submits that his immovable property has built up substantial equity as it is currently valued at approximately 8 million rands, and that equity is substantial and adequate enough as security for costs, order, and anticipated judgment in favor of the applicants. Paragraph. Further, the first respondent impugns the lack in the form of joining the disclosed party who allegedly was in a corrupt relationship with him in the proceedings which have been preferred by the SIU against him. Paragraph. It is clear to me that the relief sought by the applicants is an interim or temporary relief. Therefore, requirements of rights infringed by the applicants are less stringent. In other words, the applicants are not expected to satisfy the court on balance of probabilities. The interdict, moreover, is brought on semi-agent basis. So clearly, it is sufficient if prima facie right is shown, and in my view, it has been adequately shown by the applicants. As they only require security for the damages computed to be in the region, as already stated, of 34 million rands and well up to 40 million rands. Moreover, first respondent has already applied in the High Court for payment of his pension. The claims made by them in monetary terms far exceed the value of the first respondent's immovable property. So I am satisfied that the facts advanced by the applicants, which are not seriously disputed by the first respondent, are such that applicant should succeed. Paragraph. I do not find unreasonable delay in the bringing of the action to the tribunal. Papers filed show extensive and quite involved investigation which could not have been conducted and concluded overnight. This is also borne out by the founding affidavit and its bulky annexures. A delay of approximately one year up to 1 year, 5 months or so in the circumstances is reasonable. Especially because first respondent was expected to face disciplinary proceedings in September 2018. Therefore, requirements of interim interdict have been complied with by the applicants. These are, firstly, prima facie right on the part of the applicants. Secondly, well-grounded apprehension of irreparable harm if an interim relief is not granted. Thirdly, a balance of convenience in favor of the applicants. Fourthly, absence of any other satisfactory remedy available to the applicant. In the premises, I made the following orders. 1. The second and third respondents, that is Government Employees Pension Fund and Government Pension Administration Agency, are restrained and interdicted from paying out pension benefits or portion thereof held by them to the pension fund credit of the first respondent, namely Kgosi Lekabe, pending the final determination of an action instituted under case number SP 09/2019 on 5 December 2019 before the Special Tribunal. 2. First respondent is ordered to pay costs of this application, including the costs occasioned by the briefing to counsel. That concludes the judgment.
As a board, please, my lord.
Court adjourns.
We gave that notice to intervene in the High Court up to him. Can we have it back? Because that was our own copy. Is it there? I think it's on there.
Yeah, I'm just going to go around.
Okay, you give it to us, please.
Give us one of the copy was. Okay, maar wel dan toch, hè? Jawel, het is een van die goed geschoten.
Ons kan nie al
Dat is nie werk. Ja.
Mr.
One for the SIU. And I believe that media will I don't think that's the same. And it's all thank you. And make sure the pot is locked. But actions don't worry about it. But as long as it's locked, because somebody might come and tamper with us.
Yes. I don't want to.
All right.
Nee, ons het aanvankelijk gezwaaid om ons later een beetje meer van weg. Later gaan maar oké weer.
Weet je, is een baie les vir daai bier.
Ja, ook.
Nee, ons moet dit maar op.
Ja,
Goed.
ek weet nie of miskien maar gaan klop. Sy het nie nice.
Ja, ons boer. Ek spot net, ek het net gespot. Nee.
Baie doorskrap.
Nee, ek spot altyd. Ek sê altyd, weet ons doen sake. En as jy 'n groot saak of 'n belangrike saak of weet iemand nou hierdie is die eerste ding, die eerste in hierdie tribunaal.
Ja, dis 'n
Weet
great one.
Ek moet altyd dit half probeer vier. Maar dit gaan my en van Reinie keer, soos dit sê.
Nee, dis fyn. Ons sal nou jou ander
Om alleen op ons eie
kantoor
self in te drink nie.
Ja.
Want ons is ten minste voel ons is geregtig daarop.
Ja, nee.
Ons jy moet jouself bederf. Veral ons wen nooit regtig saak nie. Hierdie is die eerste keer wat ons 'n saak wen.
Dis wat ons so bekom.
Baie lang tyd. En ek gaan nou op praktiseer want hy het altyd gesê as ek 'n saak wen, gou ek hou dadelik op praktiseer.
Dat jy met 'n goeie rekord kan eindig.
Ja.
Hoorie, maar het sou nogal sleg gewees het vir ons as ons hier dit nie gekry het nie.
Ja, dit sou.
Ja, dit sou nie lekker gewees het. Nee, sou nie. Eerste saak nie.
Maar dis hoekom weet ons was meticulous en ons het julle waarskynlik geïrriteer om te sê ons rammel net 'n aansoek uit. En ons het vir julle sê was 'n sekere manier om hierdie goedes te doen. En ek weet julle was geïrriteerd want julle wou dit vroeër uitkry. Maar ons het dit ons het langer gevat en ding reg gedoen.
Ja.
Maar toe die ding is begin 'n momentum kyk.
Maar ek dink wat gesleer het was die request van die polisie af om ons te
Ja.
Maar wat miskien aan die ander kant ook dalk 'n goeie ding is.
Ja, kyk ons het daai klomp eise gesny want dit baie van dit sou ons
seer gemaak.
Ja, dit sou onnodig cloud op die ding gesit het.
Ja.
After all the caboose.
Nou wil jy hier sit dan neem ek vir jou foto van daai kant af.
Ja, ek het gedink Dawie moet eintlik dis haar SABC dan lyk dit asof hy daar iewers 'n kaptein was wat hoor het wat hy gesê het. Vir SABC dan
Ja, maar nog net.
Ja.
Ja, dit is nou complain. Ja.
Klein okay. Dus ik kan het gewoon niet meer van cash.
Je kan alle live. Ja, dat is
Die eisen